Good afternoon, everyone, and welcome. It's great to see such a good turnout for today's event, especially on such a busy day. As you all know, the purpose of this series is to identify and explore issues involving race, which may be uncovered or undertaught in the 1L curriculum. In constitutional law, of course, issues of race are often front and center, perhaps most obviously in discussions of equal protection. But nonetheless, there are many other important issues involving race which don't get taught. And today we have two wonderful scholars to talk us through two of those issues. We're going to start with Professor Christina Duffy Ponce Krause of Columbia Law School, who's going to talk to us about the legal status of Puerto Rico and the U.S. territories, with a special focus on the history and continuing relevance of the insular cases. And then after that, we'll hear from our own Professor Ernie Young, who will talk about the failure of the 14th Amendment to forestall the collapse of Reconstruction or to provide anything approaching equal rights for Black Americans for more than half a century. Professor Matt Adler and I will be moderating, and we have set aside plenty of time for what we hope will be a lively Q&A. So if you have questions, please don't hesitate. Go ahead and put them in the Q&A box at the bottom, and Professor Adler and I will feed them to the panelists. Having said that, I'll turn things over first to Professor Ponce Krause.
Good afternoon, everyone. I want to start by thanking Duke Law School and Professors Blocher and Adler for inviting me to present today, and to all of you for being here to learn about the insular cases of 1901. So I know some of you have encountered the insular cases and some of you haven't, so I will keep it basic and introductory, but I want to start with an observation about that fact. That some of you haven't encountered them. It's quite possible you would never have encountered them in law school if it weren't for today. The fact that you haven't heard of the insular cases is central to understanding the work they do. The insular cases have been described as central documents in the history of American racism by a leading constitutional scholar. And yet, until recently, really almost nobody had heard of them. When I was in law school, it seemed as though nobody had heard of them. I organized a conference on the insular cases and invited various important constitutional scholars, and one of them called and left me a voicemail saying, I've been teaching constitutional law for 25 years and I have never heard of these cases. Now that you've invited me to this conference and I've read them, I cannot believe I've never heard of them. We all should read them. They are foundational constitutional texts and illuminating about the United States struggle with race and racism. Why is it we don't all know about them? Well, the insular cases were made to turn invisible modern American colonies. The United States has colonies. Most Americans seem not to know that. And central to that fact is the insular cases. So I'm going to try to explain how they do that work by telling you the story of these cases. So the immediate background for the insular cases is 1898. The Spanish-American War. I bet you've heard of that, even if you're not sure what that was. It was actually Cuba's war of independence against Spain. And Cuba had been fighting Spain on and off for several decades, but in 1895, the final round of fighting broke out, and the United States got interested in this conflict. In part, the United States had always been interested in getting European imperial powers out of the Americas. You've heard of the Monroe Doctrine, I'm sure. And on top of it, the war led to a humanitarian crisis that got a lot of coverage in the American press. And so the public was interested in the United States intervening in this conflict somehow. And the United States had its own strategic interest for intervening. So in 1898, the United States intervened in the conflict by declaring war on Spain. And in the war resolution, it included a sort of caveat or a qualification that it was not entering the war to conquer Cuba. It was not entering the war to take Cuba from Spain, but rather to help liberate Cuba. And so it did. The war did not last much longer after the United States entered the conflict. And in the Treaty of Peace, the United States did not take sovereignty over Cuba, although it did take control of it. However, it did take sovereignty over Puerto Rico, the Philippines, and Guam. Spain ceded sovereignty over Puerto Rico and Guam and sold the Philippines to the United States, which also conferred sovereignty on the United States. And in the wake of these annexations, really leading up to them, as people could see what was coming, and then in the wake of them, there was a very vigorous national debate about imperialism. Okay, it's known as the debate over imperialism. What are we going to do with these places? Okay, the question of whether the United States could annex territory was certainly not new. The United States, as you know, had annexed the West over the course of the 19th century. So there was no question that the United States could annex territory. What gave rise to what is known as the debate over imperialism was the fact that these particular territories were predominantly inhabited by non-white people. And so the question that arose was, do we have to give them citizenship? Do we have to give them rights? Do we have to make them states? Or can we just take them and keep them as colonies indefinitely? So 19th century history and practice had led to the conclusion, and it had been discussed in some court opinions, most saliently actually Dred Scott, but we don't have enough time to talk too much about that. But the understanding of the 19th century was that the United States, when it annexed territory, it annexed that territory in order to make states. That the United States did not annex territory to keep colonies and be an empire like European empires, or so people described it at the time. We're not like Europeans. We have a constitution, and if we take territory, then that territory has to become a state at some point, and its people have to have the equal rights of citizenship that both citizenship and statehood get you. Okay, but in this moment, there was a lot of resistance to doing that with these new territories because of race. The imperialists in this debate argued that the United States could actually take territory and just keep it in a colonial status and not be constrained by the Constitution to any significant extent in governing the territories. And the anti-imperialists argued that, yes, the Constitution would constrain the government in governing colonies, and therefore we shouldn't take them at all, okay? The anti-imperialists weren't arguing that we should take territories and make them states. There was racism on both sides, and the anti-imperialist argument was, let's just leave these places be, let's not annex them. But the United States did annex them, and the debate found its way, as so many political debates do in this country, to the Supreme Court. The insular cases are actually a series of cases beginning in 1901 and ending in 1922, arguably, or even lasting longer than that. Scholars debated. But for sure, the most important ones were the ones decided at the beginning in 1901 and then at the end in 1922. And of those, Downs versus Bidwell was the most important of all. In Downs versus Bidwell, the dispute was a dispute over duties that the United States, that Congress had imposed on goods coming from Puerto Rico to the United States, in that case, oranges, after annexation. So I say from Puerto Rico to the United States, even though at that moment, everybody thought Puerto Rico had now become part of the United States. But the question in Downs versus Bidwell was whether Puerto Rico was part of the United States for purposes of the uniformity clause of the Constitution, which requires that all duties, imposts, and excises be uniform throughout the United States. So the case was about that language. Does the United States, as that phrase is used in the uniformity clause, include these new territories? That question somehow morphed in the way that Downs was understood. It morphed into the question of whether these territories were part of the United States, period. And the question of whether the uniformity clause applied somehow morphed into the question of whether the Constitution as such, the whole thing, applied in these territories. So Downs held that the United States, as used in the uniformity clause, that phrase, did not include the territories annexed from Spain. And the way that made it into the public, and then after that into subsequent cases, was that these territories as a group were not incorporated into the United States, and they came to be known as the unincorporated territories, and that the Constitution did not apply there except for perhaps a few fundamental provisions. So they were in a constitutional vacuum, and they were not on their way to statehood. Okay, those were the two consequences that came out of Downs as people read it. Okay, these places, maybe a few fundamental provisions apply, but for the most part, they're in a constitutional vacuum. And unincorporated territories are those that are not part of the United States in some sort of vague general sense. And what that means is not necessarily going to be states. And presto, the federal government was freed up to keep colonies and govern them with a lot of flexibility. So the opinion in Downs that actually set forth the reasoning that led to the creation of a class of territories known as unincorporated was a concurrence, not the opinion for the court. The concurrence by Justice White is known as the concurrence that created the doctrine of territorial incorporation, which is what I've just described, a near constitutional vacuum or an entire constitutional vacuum. It wasn't clear. And not on the way to statehood. The language that Justice White used is famous among those who know the cases. He said these places belong to the United States, but are not part of the United States, and thereby created a distinction that no one had ever thought about for territories before, or that at any rate had been settled for a long time. He also described the territories as foreign in a domestic sense, a phrase that is inscrutable, and so the dissents in the case argued. The dissenters said, we do not understand what it is to annex territory, not make it part of the United States. We do not understand what incorporation is. We've never heard of this before. And there's a story as to how this doctrine came to be, how it came to White. But the bottom line is these places were not part of the United States, even though they belonged to it. They were foreign in a domestic sense. Justice White's language, as well as the reasoning and the consequences, the terms he used in the opinion were explicitly racist. He wasn't hiding it. So he explained that annexation should not necessarily lead to incorporation because annexed territory might be inhabited by alien races, and we needed the power to take territory without making alien races equal to American citizens. He also explained that we could not automatically incorporate people into the United States, regardless of whether they were savages or civilized. So the racism was explicit, and the conclusion was no incorporation, and at first no citizenship either. And so the racism in the cases is quite clear. The aftermath of the insular cases saw case-by-case analysis of whether the constitutional provisions applied in these territories. And that case-by-case analysis continues to this day. Just last year, there was a dispute in the Supreme Court over whether the Appointments Clause applies in Puerto Rico, in which in the lower courts, the insular cases figured prominently. And then later in the Supreme Court, that argument was dropped, but the insular cases cast their scary shadow over the application of the Constitution to Puerto Rico in that case. So Puerto Ricans did become US citizens in 1917. Filipinos never did become citizens. And yet in 1922, in that last insular case known as Balzac versus Puerto Rico, the Supreme Court said even citizenship has not incorporated Puerto Rico into the United States. Incorporation is a step towards statehood, and the court said we are not going to interpret Congress as having done so unless Congress is unequivocal that the territory has been incorporated. Okay, even though throughout the 19th century, Congress had never thought of this as a separate step. Admission into statehood, yes, but annexation and incorporation had always been the same thing. Today, there are 5 unincorporated territories of the United States. There's Puerto Rico and Guam still, the US Virgin Islands, the Commonwealth of the Northern Mariana Islands, I mentioned Guam, and American Samoa. These places are inhabited by US citizens, all of them except American Samoa. Persons born there are US nationals, not US citizens. We can talk about what that means if we have time. These places are inhabited by US citizens. They are US soil. They are subject to US laws as long as Congress decides unilaterally to apply those laws there. And yet none of them has voting representation in the federal government. So these places can't vote for senators, they can't vote in presidential elections, and they have non-voting delegates who serve in the House of Representatives. In other words, they are quite straightforwardly American colonies. That's what they are. The United States has colonies, and it's these five. And Americans don't think of themselves as having colonies, but they have them. So 2 questions to end with. Why are they still good law? And why are they absent from the 1L curriculum? As to whether they are good law, the federal government finds these cases convenient. That's one reason, okay? It gives the federal government flexibility for handling places that what? The federal government still doesn't want to make states. And why would that be? Is it still racism? Well, it looks that way to me, but there's a lot of debate about it. The insular cases were cited in Boumediene, a case you may have heard of from 2008. That's the case that held that habeas applied in Guantanamo. Okay, so the insular cases became important for determining the extraterritorial application of the Constitution, that is the application of the Constitution abroad. Okay, so to the federal government, they have quite a value in that context, although arguably, since they concern domestic territory, maybe they shouldn't be necessary for that purpose. But the court cited them quite recently, which makes it seem unlikely that the court will decide that they are too racist to stay on the books. They are absent from the 1L curriculum, basically for the reason that I suggested at the beginning. What the insular cases did really, when you kind of step away from the technical legal concept of incorporation and the case-by-case analysis of constitutional provisions, they created a them, okay, a distinction between us and them, and that them consists of people who live under US sovereignty and who are governed by the United States and yet not fully included. And that kind of distinction where they're not really part of us, which the insular cases sort of made constitutive of these places, made them marginal, easy to ignore. Well, if they're never going to have representation, I don't have to worry about them. If they don't have equality, if the federal government's in control, I can forget about them. And that national debate that surrounded the insular cases, at the time everyone was watching, and once the insular cases were decided, the American public pretty much forgot about them. So it is in their DNA to marginalize, okay? They made optional Americans, and so they remain optional in our foundational understanding of constitutional law. So the very last thing I will say, because it probably calls for an explanation, some of you probably know that another reason that at least a place like Puerto Rico is in a state is because many Puerto Ricans themselves, not most at this point, but many don't want Puerto Rico to be a state. So that reality in the territories, there is still support for the situation that they're in to some extent. Nobody's happy about being unrepresented, okay? But the US territories as a group, none of them has a majority for independence. And most of them can't look forward to statehood. With Puerto Rico, it's a realistic possibility. And even there, the obstacles are insurmountable, okay? Well, the insular cases are central to that reality. And a curious and difficult twist to try to understand in current scholarship on the insular cases is that there are scholars who argue that the insular cases should be rehabilitated, that we should sort of set aside the racist part and keep the rest of it. Why? Because a constitutional vacuum or a near constitutional vacuum is ideal for the preservation of the local distinct cultures of the territories, which might be inconsistent with the Constitution. And so the argument is, let's appropriate these imperialist cases and use them to promote self-determination. I am not a fan of that argument, but I do acknowledge it exists. And so for those of you who get curious and start looking around, you might ask yourself, what is the significance of this? Why don't we think of these decisions like Plessy? It was the Plessy court that decided them. The opinion for the court was written by Justice Brown, the same guy who wrote the opinion for the court in Plessy, and the dissent, one of the dissents was by Justice Harlan, the guy who dissented in Plessy. So can we really strip them of their racism and redeploy them? How delicate is that task? That is something I grapple with a lot these days, and we'll be happy to talk about it more in the Q&A if we have time. Thank you.
That was truly fantastic. And all of you who are in attendance now know more about the insular cases than the vast majority of constitutional law professors. It is no exaggeration, as Professor Ponce-Krauss says, that most of us can go years or an entire career without having actually engaged with these cases. And now you all get to puzzle about questions like, what does it mean to say foreign in a domestic sense, or belonging to but not part of? Before we turn things over to Professor Young, though, I did want to just maybe sneak in one question, and it's really an invitation to elaborate the last line that you were talking about there, which I think ties in directly to of course, the status debate on the island today. And some may know that this was the subject, the statehood was the subject of a vote on the island in the fall, in early November. And in fact, on November 4th, you published an op-ed in the New York Times. I think the headline was "Make Puerto Rico a State Now." And it would be, I think, maybe helpful to say maybe a little more about the sort of middle point between the insular cases and today, that being, I would think that the compact and Public Law 600, the sort of inversion point for some, and maybe what leads to, as I take it, the sort of division between supporters of statehood and supporters of the major alternative being Commonwealth status with enhancements. And as Professor Ponce-Krauss says, support for independence very, very low and has been for a while. But could you elaborate a little more on kind of the stakes between those two?
Sure. So Puerto Rico status debate in a nutshell. So as Professor Bloger said, in Puerto Rico, there is support for statehood, to be sure, and then for something short of statehood, but also short of independence. So the division in Puerto Rico for the last 60, 70 years has been between those who want Puerto Rico just to become a state of the union on an equal footing with representation, just like the other states, and those who say, no, that's not quite right for us. We're different. Okay, so this is Puerto Ricans. This is not now, Yankee imperialists being racist. It's Puerto Ricans themselves saying, we don't want this. My own theory is that if Americans were clear that they would welcome a state of Puerto Rico, that would actually shift opinion, that part of this is a reaction to rejection, but it can't be reduced to that. And so the people who argue for an option other than statehood say, statehood would threaten our culture, and so we should have something distinct, and that distinct thing is a compact with the United States. Okay, so something analogous to the Union of States, a compact with the United States. Some of them argue that we actually already have the compact, that when Puerto Rico became a Commonwealth in 1952 and adopted its own constitution, which it did at that time with Congress's authorization, that it effectively entered into a compact with the United States that neither side can alter. And neither side being able to alter it is critical because, of course, if Congress can tweak Puerto Rico's form of self-government, well, then Puerto Rico doesn't actually have full self-government, doesn't have control over its fate, and it is a colony. Those of us who support statehood say, even if the compact binds, we say we actually don't have a compact. Congress just delegated us a little more autonomy than it usually delegates territories. Moreover, even if such a compact were possible, it's still a terrible idea. Why? Because we still don't have representation in the federal government. We still can't vote for the president or senators or representatives, et cetera. And therefore, we're still a colony. Okay. That debate has divided Puerto Ricans since the beginning. The insular cases are central to it because the idea that Puerto Rico can have a compact, that Congress could bind itself to an actual relationship with a distinct polity analogous to a state, really requires a constitutional vacuum. It has to be that Congress isn't constrained in the ordinary ways, okay? Otherwise, you couldn't do this. So explaining that relationship does take some time, but in a nutshell, without the insular cases, you can't have a compact. And so that threading that needle, these are terrible racist cases, but actually let's use them. That's the challenge that compact theorists face, as well as a challenge that people arguing for different forms of self-determination in the Pacific territories face. I hope that answered sufficiently.
Perfect. And I should say, as you've written, there's ways in which the compact theory sort of comes in from the periphery in unexpected ways, for example, in Justice Sotomayor's opinion in Aurelius, which I hope we'll have a chance to talk about. But I'm conscious too of the fact that we have Professor Young up next. And actually, your last line there is a perfect segue. Professor Young has thought and written a great deal about maintaining distinct state identities in a federalist system, which may be, something that could assuage some of the fears of compact theorists and supporters of the Commonwealth approach. In any event, I'm going to turn things over now to Professor Adler, who will introduce and moderate Professor Young's portion, and then we'll all four come back together at the end for Q&A. I see the Q&A is coming in, by the way, so keep sending in your questions. We look forward to answering them.
So I'm very pleased to introduce my colleague, Ernie Young. Ernie is one of the leading scholars of constitutional federalism. If I want to learn about American federalism, I read Ernie. He has been at Duke Law since 2008. He teaches a legendary class on federal courts. I think you get about 50 credits for taking it, but this is a really, truly deep understanding of federal courts, as well as constitutional law, and some terrific seminars. So without further ado, I'll turn it over to Ernie to talk about the 14th Amendment and its failure to prevent the collapse of Reconstruction.
All right, well, thank you, Matt, for that very nice introduction. I wish when we were introduced here at Duke, we would just say something like, this is Ernie Young, he works here. I also want to thank Joseph Blocher for organizing the panel and Daryl Miller for overseeing this whole series on race in the 1L curriculum, as well as Christina Ponza-Kraus for joining us. One of the more frequent criticisms of the role of race in the 1L curriculum is that it's ignored. Right? But I want to underscore Professor Blocher's point that this just isn't possible in constitutional law. Slavery is the original sin of American constitutionalism, and the racism that slavery inspired, which extended to other groups besides Black people, is a pervasive preoccupation in the course. And that's true even if your version of the course focuses, as mine does, on the structural Constitution rather than, say, the 14th Amendment. As a teacher and scholar of federalism, for instance, I'm constantly confronted by the way that broad national power, on the one hand, propped up slavery in the antebellum republic, and the way that states' rights ideology was employed to shield Jim Crow segregation in the 20th century. There's just no hiding from questions of race in our course. That doesn't mean, though, that the impact or significance of race for constitutional law is fully understood or that there isn't interesting work to be done. So I want to share with you a project that I've been working on for a couple of years now that explores the implications of a particularly frustrating episode in America's constitutional effort to deal with race through the law. That project, which I'm calling Dying Constitutionalism and the Lost Years of the 14th Amendment, will ultimately be a book about constitutional theory, but built around a particular historical story. That story goes like this. At the end of the Civil War, the victorious North tried to establish a regime of freedom and equality, especially for Black Americans. They reordered Southern politics by disqualifying former Confederates and giving freedmen the vote. They forbade oppressive labor practices and taught freed people to read. They kept Union troops in the South and they broke the Klan. And they tried to entrench all these gains, the fruits of a victory that cost the lives of 750,000 Americans, by adding 3 amendments to the Constitution. The amendments were adopted, but the effort failed nonetheless. Over time, white supremacists retook control of Southern governments. They murdered, defrauded, and intimidated Black voters. They established Jim Crow segregation to constantly remind Black people of their subordinate position. Southern Democrats could do this largely because Northern or national politicians let them. Presidents forswore military intervention. Congress failed to enforce constitutional penalties for disenfranchisement, discontinued the Freedmen's Bureau, and repealed voting rights legislation. And the Supreme Court interpreted the new amendments narrowly. My central question is, why did the effort to entrench the gains of the war through the Reconstruction Amendments fail? The first thing that jumps off of this historical record, at least for me, is that it failed in all the ways that living constitutional theory, say constitutional meaning, can change over time. So the shrinking 14th Amendment reflected widespread changes in public opinion. Michael McConnell has demonstrated that the Compromise of 1876, which effectively ended Reconstruction, has all the hallmarks of an Acrimanian constitutional moment. in which a politically mobilized majority effectively forces a change in constitutional understanding through electoral politics. Two strong social movements, the white supremacist Redeemers and the Reunionists, who wanted to forget about race in the interest of getting the country back together. They both impressed their vision on the Constitution, and judicial decisions narrowing the 14th Amendment, like Cruikshank, the civil rights cases, and Plessy versus Ferguson, can be seen as a stream of common law constitutional development. The meaning of the 14th Amendment changed over this period in an organic way, but instead of living, evolving, and flourishing, the amendment mutated, decayed, and nearly died. So that's the core argument. Living constitutionalism can go very wrong, and we need to think hard about how to better entrench constitutional principles to prevent this sort of decay. So let me use what remains of my time to say just a couple of things that may help orient this project, which may not be altogether clear from what I've said thus far. First, I know this argument sounds like an attack on living constitutionalism, but it's not. I am myself a living constitutionalist. But I do share with originalists a conservative sensibility that a central problem of constitutionalism is not just how to push society forward, but rather how to hold on to the gains that we've already made. My hope is that thinking about how living constitutionalism went so badly wrong in the late 19th and early 20th centuries will encourage living constitutionalists to think more about constitutional entrenchment. Second, I'm not a historian. I haven't discovered anything new about the history here, and I'm trying to bracket most of the disputed questions about the history of the 14th Amendment's original meaning. My task as a constitutional lawyer is to assess how this historical story maps onto certain debates in constitutional theory. And the key thing I derive from the history is that constitutional law hasn't assimilated an important change in Reconstruction historiography. That change is to see Reconstruction as not simply a failure, but rather as an all too brief success that we failed to hang on to. To see that presents the 14th Amendment's failure in a different light. It was not just a failure to follow through on a constitutional aspiration, but it was also a failure to entrench gains that had already been made at very high cost. Third, the erosion of the 14th Amendment in its lost years highlights living constitutionalism's need for a theory of entrenchment. That is, a theory that would say when and how we should resist changes in constitutional meaning. In this sense, living constitutionalism needs to become a little more like originalism. Originalism is good at entrenchment, but because living constitutionalists tend to spend more time either critiquing originalism or exploring new avenues of change, they haven't thought much about how to lock in the constitutional principles they support. But I think the lost years also show that the debate isn't really about methodology. Both living constitutionalists and originalists need to think about how entrenchment is separate from interpretive methodology. We've all assumed that once you get something accepted as in the Constitution, it's safe and effective. So the only question is interpretive. What's in there? But that just wasn't true for the 14th Amendment in the late 19th century. The judges that interpreted the amendment in line with changing social, moral, and political landscape around them didn't think of themselves as either living constitutionalists or originalists. Maybe if they'd had a firmer set of methodological commitments, that might have made a difference. But I doubt methodology is enough to check the forces operating on the courts in this period. And in any event, a lot of the key constitutional decisions, such as decisions not to invoke Section 2 of the 14th Amendment to reduce Southern representation in Congress, or to deploy more troops to the South, weren't being made by courts or judges who had really thought about interpretive method. Fourth, I think living constitutionalism also needs a theory of original meaning. That need is acute for living constitutionalist scholars like myself who want to study constitutional change. I want to study the historical arc of change. And in order to do that, I need to locate the arc's start point. That is the 14th Amendment's original meaning. I'm not sure I need to identify it as precisely as an originalist would, but I can't avoid that question. In fact, it may be that questions of historical meaning are even more pervasive for living constitutionalists. A widely held version of living constitutionalism, and one I subscribe to, says that all of our history is relevant, not just the originalist snapshot of meaning at a constitutional provision's inception. That proliferates the problem of determining what a constitutional provision meant at any given point in history. But I think it means that living constitutionalists don't have the option of just giving up on historical meaning. The fifth point is inspired in part by Jamal Green's work on 14th Amendment originalism, which argues that constitutional theory is in many ways a question not so much of method as of identity, or as I would put it, of culture. So Professor Green wrote that originalists were uncomfortable with the 14th Amendment because it was redemptive in nature, while originalists identify with preserving the existing order and resisting change. But the point I want to make is that constitutionalists who identify in this conservative way ought to embrace the 14th Amendment as the castle they are set to defend. And living constitutionalism actually needs more of that conservative culture to hang on to the gains that it achieves, like the Reconstruction Amendments. Finally, I know every piece of legal scholarship is expected to answer Lenin's famous question, what is to be done? I've tried a bit in the last section of this project to do that, but as I've already suggested, I'm not going to try to come up with some new take on interpretive methodology. One lesson in my story is that living constitutionalism is not so much a theory of interpretation as something that happens to you when you're trying to apply whatever methodology you thought was best. Especially when provisions are open-ended or unclear, like the 14th Amendment, it's hard for interpreters not to be influenced by strong social forces, whether consciously or unconsciously. When we're talking about how to make constitutional entrenchment stronger, the problem is one of culture more than of methodology. I need to work a lot more on figuring out exactly how culture works. But I do think that constitutional culture in this country is profoundly shaped by a few basic narratives about successes and failures. The story of the Lochner era, the New Deal crisis, and the court's switch in time influences interpretation across methodologies and across institutions. Nobody wants to make those mistakes again. And so those precedents are profoundly powerful as a cautionary tale of what not to do. The story of the 14th Amendment's lost years ought to play a similar cautionary role. It ought to give constitutionalism a sense of tragedy, of what is to be lost, as well as what is to be gained when constitutional meaning freely evolves. I don't think most constitutional lawyers, and certainly not most law students, know this story. I think if they did, they might think and behave a little differently. That, at least, I think, is a place to begin. Thanks.
Thank you, Ernie, for that really thought-provoking lecture, but an interesting project. I'm looking forward to reading it. One question, I think those one of us who've taken constitutional law know that, there's certainly cases from the period which we now reject, like Plessy, but there are cases from that period that remain foundational. I'm thinking in particular of the Slaughterhouse cases and the civil rights cases. The Slaughterhouse cases adopting, a super narrow reading of 14th Amendment privileged immunities, right? The only current justice, I take it, who wants to overrule that is Justice Thomas, and the civil rights cases establishing both that constitutional rights bind only the states, that is governments, and adopting a narrow understanding of Congress's power to enforce the 14th Amendment, reaffirmed in Morrison. Are those wrong? I don't see a lot of originalists on the court now arguing for overruling either Slaughterhouse, in particular the civil rights cases, and should kind of an originalism as applied to the Civil War amendments lead us to think about overruling those cases?
So I think the civil rights cases are wrong, not because they said there was a state action doctrine in the Constitution, but because they thought state inaction didn't count. Right? So the Equal Protection Clause says that people are entitled to the equal protection of the laws enforced. That's kind of the minimal meaning. There might, maybe much more than that, but you're entitled to the laws enforced. You're in particular entitled to the equal protection of the public accommodations laws, which is all that the 1875 Act tried to require. Right? And so I think that the court should have said the state's failure to enforce their public accommodations laws equally when it came to Black people's rights was a sufficient predicate for Congress to legislate on that subject. So I think that's the sense in which I think that they are wrong. You don't have to change state action doctrine particularly to assimilate that, but I think it was in that context, it was a wrong decision and a disastrous decision. I think the Slaughterhouse cases are less central than most people do, and maybe I'm wrong about this. Everybody seems to disagree, but plaintiffs in the slaughterhouse cases are white. They're asserting a kind of right to work claim. And so that's kind of peripheral. And the majority says that's peripheral to the main event of Reconstruction, which is achieving equal rights and equal protection for Black people. And so I don't think the slaughterhouse cases should play this central role. I think the actual issue of what privileges and immunities meant, particularly when you consider that every privilege and immunity that you recognize is going to be an extension of national legislative power as well. That's a very tough question. The other thing that is usually laid at the civil rights case or the slaughterhouse cases doors is that it foreclosed incorporation of the Bill of Rights through the 14th Amendment. But again, that wasn't before the court either. So I don't think, it would have been wrong to reject that, but it didn't.
Right. But in terms of current implications, which is very plausible, saying that the civil rights cases are wrong for not recognizing state inaction as a kind of action would mean that Morrison's invalidation of the Violence Against Women's Act is wrong. Is that right?
I think Morrison is a lot less straightforward because you had one pervasive wrong and one pervasive kind of inaction in the civil rights cases. Every state in the union had public accommodations laws, and the vast majority of the ones in most of the country did not apply them equally to Black people. The problem with the Violence Against Women Act was trying to solve was a lot more variegated, right? So there were spousal rape exemption or the spousal testimonial privilege. There was just the attitudes of juries and the attitudes of state prosecutors, any number of other evidentiary rules, funding levels that were inadequate to prosecute violence against women's crimes at the state level. It's not clear that all of those failures were themselves unconstitutional in the way that a failure to enforce a public accommodation law equally would be. And so I think Morrison's a lot more complicated. But yeah, I think the Section 5 argument in Morrison was a lot stronger than the court gave it credit for.
Great. So Joseph, are we going to go to questions for Professor Ponce-Krauss, or what's the
Yeah, let's do that. We're going to have now sort of an open Q&A, and our queue seems to be filling up. Questions are filtering in, which is great. If you've been holding yours, now would be the time to enter it for either Professor Ponce-Krauss or for Professor Young. But why don't we start with the first question actually we received, I think nicely shows some connective tissue between the two projects and discussions here, because as Professor Young did, it discusses rather Plessy versus Ferguson. So I think this is directly a question for Professor Ponce-Krauss, and I'll just read it here. The insular cases have been compared to Plessy versus Ferguson by critics such as First Circuit Judge Juan Torreya. Despite being U.S. citizens, Puerto Ricans are treated unequally from those in the rest of the nation solely by reason of their geographic residence. Judge Torreya has outlined a history of colonialism tracing from before 1900 to modern day. And here's, I think, the crux of the question, which ties together the insular cases and the status debate you gave it that nice encapsulation of. Do you see any way that the Supreme Court could, at some point in the conceivable future, overturn the insular cases and give Puerto Ricans the full rights afforded to mainland US citizens without, in all caps, without necessarily having to resolve the status issue? And the model here, the questioner says, thinking of an arrangement similar to that of the French overseas departments, places presumably like Martinique. What do you think?
So thank you for that multi-layered question. I do see a way for the Supreme Court to overturn the insular cases without resolving the status debate. However, I don't see a way for Puerto Ricans to have the full rights afforded to mainland US citizens without resolving the status debate. So you can overturn the insular cases, and what that does, I think, is facilitate a solution to the status debate. But to have the full rights of mainland citizens, Puerto Rico has to be a state. It's really as simple as that. We can argue about it till the end of time. And I will not understand how anybody could see it otherwise. You can have something different, but you can't have the full rights of US citizens unless Puerto Rico becomes a state. So how could the insular cases do this? I'm going to describe ongoing litigation, and this actually, I think, will partially answer the second question, which is about current arguments to resurrect the insular cases as well. And that, I think, will help you see a way that the court could overturn the insular cases, and then I'll be a little clearer about the implications for status. So right now, there is ongoing litigation in the 10th Circuit. There was a decision on this in the DC Circuit a few years ago, and now there's ongoing litigation in the 10th Circuit over the question of whether the citizenship clause of the 14th Amendment applies to American Samoa. So as I mentioned in my remarks, American Samoans, persons born in American Samoa, are US nationals, not US citizens. That distinction dates from the insular cases era. There was a case in which, a few years after Downs, in which the court said that Puerto Ricans, and by implication of people of other unincorporated territories, were Americans, but being an American didn't necessarily make you a citizen. And so the court did not directly address the constitutional question, does the citizenship clause apply? But it implied that it thought it probably didn't, though it explicitly said we're not answering that question. So as you all probably know, the citizenship clause also uses the phrase United States, right? It guarantees citizenship to persons born in the United States and subject to the jurisdiction thereof, born or naturalized in the United States and subject to the jurisdiction thereof. And the plaintiffs in the American Samoa cases are people who've moved to the mainland, but remain US nationals and therefore don't have the same statutory rights, really, because as you probably talk about a little bit in constitutional law, constitutional rights are really for persons and people, not for citizens. That too oversimplifies matters, but these people don't have the same statutory rights as citizens. They can't vote. So American Samoans living in California and Texas, various places, have sued to say, hey, we should be treated as citizens. The American Samoan government has intervened against the plaintiffs. So the American Samoan government has taken the side of the United States in arguing that the citizenship clause does not apply to American Samoa. And what do they cite? The insular cases. And what do they say? Constitutional vacuum. And the way that the jurisprudence has developed, basically the question is, would it be impractical or anomalous to extend the constitutional provision in question? So really, almost explicitly, it's a matter of sort of policy and convenience, okay? This isn't true for every single constitutional provision in the unincorporated territories, but it is for many. And the DC Circuit held that the citizenship clause did not apply in American Samoa because it would be impractical and anomalous to apply it. Why would it be? They are already US nationals, right? Why would it be impractical and anomalous? Because the American Samoan government, which represents the Samoan people, rejects it. So it's this, that is not the way the citizenship clause is supposed to work. It's not supposed to be subject to a majoritarian decision, but there the insular cases are playing that role. So the argument on the other side is that the insular cases shouldn't govern this because the citizenship clause is not the same as the uniformity clause, and that actually Wong Kim Ark, which is the 19th century case that broadly interpreted the citizenship clause, should be the case that governs. And according to its reasoning, the United States is defined broadly in the citizenship clause. So I think this case could go to the Supreme Court. Wouldn't that be nice? If the 10th Circuit comes out the other way, then this case could go to the Supreme Court. And the Supreme Court there would have an opportunity to overrule the insular cases. And what would that look like? Okay, the court could say, we reject the distinction between incorporated and unincorporated territories. Okay, they made it up. They made it up for racist reasons, whatever. We reject it. Okay, and then what would happen? So certainly the citizenship clause would apply. But on top of it, you would now not have all that room in between statehood and independence. So this is how it wouldn't, you wouldn't then, also decree that Puerto Rico is a state. It doesn't work that way, okay? But if the insular cases were overruled and there's no distinction between incorporated and unincorporated territories, well, then territories are a temporary status. It was on the way to statehood. I think in this day and age, you could at that point give the territories a choice, statehood or independence. What you wouldn't have is the in-between. So I don't want to take up too much time. There's so much more to be said there, but the overruling the insular case is definitely possible. this particular litigation offers an opportunity. And what you rule out is this eternal limbo. And what you put on the table at that point is in or out. And then Congress would have to make that happen.
All right, let me, thank you, Professor Ponce-Krauss. Let me shift over to Ernie. I see a question actually from our colleague, Neil Siegel. So Ernie, this is from Neil. There is much truth in what you write and say, but don't you also need to acknowledge that the 14th Amendment almost certainly would not have been ratified had it been thought that it would prohibit racial segregation in public education and prohibit interracial and prohibit bans on interracial marriage. That living constitutionalism also brought us Brown and Loving.
So I agree with almost all of that. I wouldn't be a living constitutionalist if I thought it was all bad, right? And I think that living constitutionalism is absolutely at the center of the turn of the tide that happens later. I think what's left out in kind of our celebration of the ability of living constitutionalism to promote moral progress is the recognition that it can also, endorse and constitutionalize backsliding, right? And so I think in many ways we were closer to Brown and Loving in 1868 than we were in 1930 after we decided cases like Plessy. And when we had to go a long way, a lot of evolution to get back from Plessy, that if we'd held on to the idea that the 14th Amendment embodied a commitment to constitutionalize the fruits of the war, one of which was to overthrow this oppressive social system in the South, and not reinstitute anything that looked like that, like Jim Crow, for instance, then I think it might have been easier. I've always been persuaded by Alexander Bickle's survey of the history, which found that on the one hand, nobody probably expected in 1868 that the immediate result of the 14th Amendment would be to get rid of segregation or bans on interracial marriage. But at the same time, there was a very deliberate choice to use broad language and not put in any specific, locking in a particular, status quo. And so I think that in many ways means that originalists have to be living constitutionalists to some extent. I also think the historical evidence that the very next Congress, which had mostly brought you the 14th Amendment, was willing to vote by significant majorities, although not super majorities sufficient to overcome resistance, for desegregating the schools, suggests that even the originalist case for Brown at least was closer than we might have thought. So we might not have been that far from where we originally got to if we'd held on a little better.
Let me add one more question for Professor Ponce-Krauss. This comes from our recent graduate, Daniel Rice, who had a wonderful Duke Law Journal note on territorial annexation, in fact. And the question is this: in the congressional debates over annexing Hawaii, there was lots of sniping about whether Native Hawaiians would enjoy full voting rights and other rights if annexation were successful. Do you think the doctrine of territorial incorporation, which you described from the insular cases, functioned to preserve America's post-1876 racial entente by making it unnecessary for politicians to confront these basic questions of racial justice? And here I'm thinking of David Bly's book, Race and Reunion.
Yes, the answer is yes. And so actually, I recognize Daniel Rice's name. I know that piece, and I wrote a Jotwell essay on it, meaning I love his piece. So the question just disappeared, but I paid attention to it. I think absolutely. So a couple things. So first of all, I've been wanting to say that for those who are interested in further exploring the relationship between Reconstruction and the imperialist period, and the argument that Professor Young is making and what I'm trying to describe here, there's a recent book by Professor Sam Ehrman from USC called Almost Citizens, which is really all about the ways in which the imperialist, so I say imperialist because that's the term that we traditionally apply. I think the United States is an empire and always has been, but the imperialist moment around 1898 is is yet another step in the dismantling of what he describes as the Reconstruction Constitution, which is the Constitution that made certain promises, the understanding of the Constitution as making certain promises that were then not fulfilled or betrayed. So Professor Ehrman describes the process whereby what the Reconstruction Amendments were intended to achieve slowly, well, violently and gradually ceases to be part of the promise of those amendments, and then tells the story of imperialism as a sort of final dismantling and a yielding of that Reconstruction Constitution to an imperial one. And part of that process is a set of arguments during, before, during, and after the Insular cases, insisting that citizenship is really empty, that the concern about annexing territories and granting citizenship to their inhabitants is misplaced. Because look at minors, look at women, look at Black people. We can make people citizens and still really not fully include them, not fully enfranchise them. We've done it forever. So the idea that the doctrine of territorial incorporation provides an out, allows for a sort of reconciliation, as Professor Blight writes about in Race and Reunion, a reconciliation between North and South, Democrat and Republican, and what you have now is a sort of a nation reunited to some extent at the expense of these colonies is absolutely right. And so seeing the way Ehrman describes it, just seeing citizenship be gradually emptied of its content until finally in 1917, when Congress comes around to granting Puerto Rican citizenship, their own non-voting representative has come to the conclusion, actually, we don't want it anymore. It's painful. And it is part of that longer story about what happens to citizenship and equality and rights during and after Reconstruction. So these stories, these are all chapters in that story. And the role of empire in sort of freeing politicians from having to deal with these questions is critical to understanding them. And just real quickly, I'll say, of course, Hawaii became a state. And Hawaii, that we knew Hawaii was going to be a state when the court in another of the Insular cases distinguished between Hawaii and the territories annexed from Spain. It really could have gone either way. The fact that there was a strong white missionary population in Hawaii played some role, but I interpret it even as the court really, it's trying to finesse this line, and it finds a way of doing so with Hawaii, about which one we'll learn more if one reads this scholarship. That's really what put Hawaii on that track. And once everybody accepts it's going to happen, then it's more likely to happen.
Your reference to sort of chapters yet unwritten is a great place to end. We have a question, apologies to those still on the queue, especially the question here about how the Insular cases and the law of territories apply to the settlement of Mars or another planet, given the recent landing of the Perseverance rover on Mars. Those are questions you all have to just sort of ponder on your own. Wherever you are, though, please join me in
thanking. You can email me.
Or you can email Professor Ponce-Krauss. Thank you for the generous offer. And wherever you are, please join me in thanking our panelists. And with that, I will go ahead and close the proceedings for today. Thank you all so much for being here. And please remember to mark your calendars for the next event in this series, which, as you can see from the slide, is going to be Tuesday, March 23rd at